You're listening to Clearly Conspicuous, a podcast series brought to you by Holland & Knight's Consumer Protection Defense and Compliance Team. Here at Holland & Knight, we have the working knowledge of how federal and state agencies operate and how courts address consumer protection issues. Consumer protection laws and regulations impact every dimension of business. Aggressive federal and state agencies are getting the attention of senior executives who are concerned about risk management, compliance challenges, and high-profile governmental inquiries. Holland & Knight's Consumer Protection Defense and Compliance Team has the experience, knowledge, relationships, and platform to effectively work with our clients to address these issues.
Good day, this is Anthony DiResta. Welcome to our sixth podcast of Clearly Conspicuous. As we noted in the previous sessions, our goal in these podcasts is to make you succeed in this environment, make you aware of what's going on with the regulators, and give you practical tips for success. It's a privilege to be with you today. And today we talk about another FTC enforcement priority, the topic being Made in the USA claims. The Federal Trade Commission has increasingly prosecuted more deceptive U.S. origin claims under Section 5 of the FTC Act since the start of the COVID-19 pandemic than in the previous decade. This uptick in administrative enforcement increases the cost of compliance surrounding Made in the USA claims, and companies should take notice regarding any origin claims they intend to make. In addition, in 2021, the FTC adopted the Made in USA labeling rule, which codifies and clarifies the FTC's long-standing position and guidance on U.S. origin claims. The rule establishes the FTC's ability to pursue potentially strict punishment for those who violate the rule's mandate related to product labeling. The FTC regulates U.S. origin claims under its general authority to act against deceptive acts and practices. Simply put, a Made in the USA claim must be truthful and substantiated prior to the claim being made. For a marketer to substantiate an unqualified claim that a product is made in the United States, the marketer must, at the time they make the representation, rely upon a reasonable basis that the product is, quote, all or virtually all made in the United States. There is no hard and fast rule to prove compliance with the FTC's all or virtual all standard, but the product should contain no or negligible foreign content. As codified in the rule, a marketer must satisfy three prongs to label the product as made, manufactured, built, produced, created, or crafted in the United States. First, final assembly or processing of the product occurs in the United States. Second, all significant processing that goes into the product occurs in the United States. And third, all or virtually all ingredients or components of the product are made and sourced in the United States. The FTC considers a number of factors when determining whether a product meets this standard. The FTC will likewise examine the percentage of a product's total manufacturing costs that are attributable to United States-related costs on a case-by-case basis. The FTC will consider the remoteness of foreign content, including the percentage of the product's foreign material cost, in addition to the degree to which foreign content is removed from the finished product. The FTC has released business guidance to assist companies in complying with the all or virtually all standard. Remember, companies have a continuing obligation to ensure that their claims are truthful and substantiated, including when they temporarily changing a supply chain to outside the United States. For a company to make a lawful, unqualified U.S. origin claim, the final assembly of the product must occur within the United States. All significant processing that goes into the product must occur in the United States, and all or virtually all of the product's parts, ingredients, or components and processing must be made or sourced in the United States. For a company to make a lawful qualified U.S. origin claim, the company must include a clear and conspicuous qualification that, one, appears immediately adjacent to the representation, and two, accurately conveys the extent to which the product contains foreign parts, ingredients, or components, and/or processing. For a company to make a lawful claim that a product was assembled in the United States, the product must be last substantially transformed in the United States. The product's principal assembly must take place in the United States, and the U.S. assembly operations must be substantial. Some of the key requirements which all advertisers should keep in mind when they are thinking about their disclosure include: when the claim is made in a television commercial or audiovisual advertising, the disclosure should be presented simultaneously in both the audio and the video. Disclosures in interactive electronic mediums must be unavoidable. On product labels, the disclosure must be presented on the principal display panel. And finally, when qualifying the U.S. origin claim, the disclosure must appear immediately adjacent to the representation, and it must accurately convey, quote, the extent to which the product contains foreign parts, ingredients, or components and/or processing, close quote. So here's the key takeaway. If you make claims expressing made in the USA, pay strict attention to the FTC's guidance and actions. So please stay tuned to further programs as we identify and address the key issues and developments and provide strategies for success. I wish you continued success and a meaningful day. Thank you.
Thank you for listening to Clearly Conspicuous. For more information on our Consumer Protection Defense and Compliance team, visit hklaw.com/CPDC or email anthony.diresta@hklaw.com with any questions about today's episode.